I'm Jyodh Bilan, editorial assistant at Trade Finance Global, and we are at ICC Austria's Trade Finance Week held here in Vienna. I'm delighted to be joined by Jin Saibo, PhD of law and attorney at law at Beijing, Jincheng, Tongda and Neal law firm. Today we will be talking about the evolution of ICC Austria's Trade Finance Week, China's adoption of URDG rules, and its involvement in the UNCITRAL initiative on negotiable cargo documents. Jin, welcome to Trade Finance Talks.
Sure, thank you.
So firstly, could you tell us who you are, where you're from, and what you do?
Okay, my name is Jin Saibo. Jin is my family name. Saibo is my given name. I am a lawyer in China, and our law firm have totally over 15 offices around China, and we have also have a Tokyo office, Hong Kong office, and my business is mainly focused on international banking law and practice. Means I'm a litigator and arbitrator, so my main business is focused on international trade finance, including the case involved like a letter of credit, documentary credit, and standby letter of credit, demand guarantee, and other we call supply chain finance, like forfeiting, factoring, is all in my business. And yes, I do a lot of litigation case, not only in China but also in another jurisdiction. And in the past, I do a lot of research and in academic side, because I'm a lecturer on the several top law school in China, and giving a lot of lecture to the local banker, trader, lawyer, including the local judge, the judge in the Supreme People's Court. So I published over 20 books, including e-books, both in Chinese and English. Thank you.
Thank you, Jin. So you've been attending ICC Austria's Trade Finance Week since the beginnings in the mid-2000s. Can you tell us why you've been attending so consistently, and maybe how the event has changed over the course of these years?
Yes, as I mentioned the day before yesterday, and I said we Chinese needed to learn a lot of Kung Fu. The documentary credit Kung Fu, demand guarantee Kung Fu, and standby Kung Fu if we China want to do international business, including the international banking business. But all this banking practice and legal practice is developed by the American Bank Society, Legal Society, and the Europe Bank Society and the Legal Society. So that's why we need to study this kind of Kung Fu to service our China's international business. I'm constantly attending all these events all over the world, including the events in the United States by IIBLP, the ICC headquarters annual meeting all over the world. And in Europe, I mainly participating in this Trade Finance Week. I have joined this meeting not as a participator, but also an important speaker on these events over 20 years. I learned a lot, especially on the guarantee Kung Fu here from the ICC Austria Vienna events.
Thank you. So I guess now focusing more on your legal expertise, what led to China adopting the URDG rules as domestic law? And are there any significant differences between Chinese domestic law and the URDG rules that practitioners should be aware of? And perhaps you could also tell us what's to come next.
Yeah. As UCP is the Bible of letter of credit, and URDG is a Bible of demand guarantee. So that's why, if we, China, want to doing business with the country outside of China, like a European country and another country in the Middle East. I think we must follow in we call international standard banking practice. So URDG is the Bible on demand guarantee and mainly developed by the Bank Society and the Legal Society in Europe. And in the very beginning, when we China, when I helped the China Supreme People's Court drafting the guarantee laws, in the very beginning, we have already make our mind clear that our law must harmonize with the law and practice here in Europe, and even the local law in Europe. So that's why in the very beginning we decided to adopt URDG as a set of international banking law and practice. And not only from URDG 458, but also URDG 758. We Chinese ICC China have sent our representative to the drafting team of the URDG, and the ISDGP, because ISDGP is a development, detailed practice standard for demand guarantee. And in our law, guarantee law, the drafting by the Supreme People's Court, in Article 5, this article said the Chinese court will follow in the agreement which the guarantee itself said is subject to URDG. So the Chinese court will respect with this choice by the parties of the guarantee. But if the issue related with the fraud and injunction or other like legal remedy, like for example the beneficiary abuse his rights of demand or rights of claim under the guarantee, or purely the beneficiary make a fraudulent presentation under the guarantee, and what kinds of legal remedy was provided by the Chinese law. So here in our guarantee laws, we follow in two things. The first is we must follow in the so-called international standard banking practice of demand guarantee like URDG and ISDGP, but in the same time, we want to keep a balance. If the beneficiary abuse his rights under guarantee, we Chinese should stop him. And that is in the very beginning, we want to finish these two kinds of work. But surprisingly, we in these guarantee laws, in Article 21, the laws said if a guarantee is a demand guarantee transaction is a domestic demand guarantee transaction in China. For example, the issuer of the guarantee is the local Chinese bank, and the local beneficiary is located in China. We call this kinds of guarantee transaction called domestic demand guarantee transaction within China for the underlying transaction in China. So under these circumstances, our law also said URDG will also apply if the parties agree to subject to URDG. That is a very important change, because we apply URDG, this set of laws called international banking law and practice, in our domestic transaction. That is very important change, So the URDG here developed in Europe and the United States and United Kingdom, and today could be directly apply the case or transactions in domestic transaction of the money guarantee in China. That's very big change for us.
Thank you. And so China's been a strong driver of the UNCITRAL Working Group 6 initiative on negotiable cargo documents. Could you outline why this initiative is of particular interest, especially given that the most common form of transport is rail service?
Yeah, that's another very important topic about what we call digital international trade documents. And as the UNCITRAL have already developed a model law of assignable or transferable electronic record, or the English law called the transferable trade documents. We, China, have been suggested by UNCITRAL to adopt the model law of transferable electronic record. And some experts have suggested the draft of the law to the Department of Commerce of China. I have been invited to join the seminar in Beijing last year to adopt the model law of transferable electronic documents in China according the agreement under the APEC or NAFTA network. But my suggestion is it is too difficult to adopt this kind of model law because this model law the model law on international trade documents, digital international trade documents, is not only related with the law of negotiable instrument law, which I think we have finished the most job because over 95% of our Chinese local electronic negotiable instruments have already transferred in our we call bill of exchange market in Shanghai in electronic way. Over 95 or 99% of our negotiable instrument transaction already in the digital way or electronic way. But if we want to use electronic or digital bill of lading or digital warehouse receipt or digital we call commercial invoice, we need to change not only the law of negotiable instrument, but also change our maritime law and the law of warehouse receipt, and the law of storage, in our civil code, and another very important we call statute that the People's Congress made. So I think it is almost impossible to change all these kinds of law which have passed by People's Congress because the procedure for the People's Congress to change these kinds of statute is very difficult and time-consuming and cost a lot of energy, time, and expertise. So my strong recommendation to the Commerce of Department of China and UNCITRAL staffs that we need to find the help from the Supreme People's Court. Like in letter of credit field, we have AOC law drafted and published by the Supreme People's Court. In demand guarantee, we have law on the demand guarantee. It is quite easier to asking Supreme People's Court to make we call a law, or the technical term is justice interpretation, because the Supreme People's Court have the authority from the People's Congress to make law. This law's name is justice interpretation, but it is still law. So it is easier than to apply the People's Congress, then to turn to the Supreme People's Court to make a set of law related with the digital international trade documents. Then we can put in all these electronic or digital things in this law. For example, including the issue related with the digital bill of lading, digital warehouse receipt, digital invoice, digital letter of credit, even digital guarantee, digital forfeiting, digital factoring transactions. Because yesterday when I was in the meeting room in the events, ICC Austria events, I look at all the case judged by the Chinese court about e-bill of lading and e-warehouse receipt. I feel it is quite good, because the Chinese court already hearing hundreds, thousands of cases about digital bill of lading and digital warehouse receipt, digital negotiable instrument case, and then the judge must give in the judgment, the answer to this case. So if they have thousands of cases needed to be decided, needed to be answered, needed to be given delivery their judgment, then the Supreme People's Court will feel it is necessary to unify all the judges nationwide in China to make their judgment following the same set of rules. That's my next suggestion to the Supreme People's Court. But I will start to giving a lecture focused on electronic documents on international trade and international trade finance.
Thank you. So shifting focus back to Trade Finance Week here in Vienna. So next May, ICC Austria will host its 20th Global Conference on Bank Guarantees. As mentioned earlier, you've been a speaker from early on. What do you think makes this platform so invaluable for practitioners?
Yeah, the ICC Austria's event, I think, is so important, not just only for me, but also for our China, especially the Supreme People's Court of China, because when we preparing to drafting the laws on demand guarantee, I think the first model would be the URDG and the model law in the different countries, like the law in French, because the law of the independent guarantee in French a couple of years ago, they changed a lot. So why I'm coming to here, because first, I can correct a lot of information and materials, and the case and the banking practice, the deep thinking or insight from the expertise here in this event. Every time after I back to China, I just reprint all these materials in the events and provide and deliver it to the judge in Supreme People's Court, who is responsible to drafting this law. So here, when I was going this ICC Austria's Trade Finance Week, so many years, because I need to follow in, following the banking practice, the legal practice, the case development, and also the problem we face in our practice. So I would say it is very helpful, this Trade Finance Week in Vienna organized by ICC Austria. It is, our law, I can say, is pregnant here in Vienna, and we learn a lot and we adopt a lot of model rules, model laws here in this society. And I would like to thank of these events because it's so helpful for our China. And that's why in the very beginning, I already make our mind clear that we must make our laws very harmonized with the law and banking practice here. Not only in Europe, but also over the world. Our law must be harmonized with them. And the operation smoothly, not only in China, but also, in the European country, United States, United Kingdom, North Europe, and Middle East, and the East Europe country like Kazakhstan, Kyrgyzstan, Mongolia, Georgia, Armenia, like this country in our One Belt, One Road initiative country. I would say thank you for this event. I will going to, keep to going to join this events to as a speaker, to report and update the situation, the case, the new development in China, as exchange, information and opinion, inside exchange between the Chinese bank society, legal society, and the banking society and legal society in Europe as well.
Thank you, Jin. That was Jin Saibo from Beijing, Jincheng, Tongda, and Neal law firm, and we're here at ICC Austria's Trade Finance Week in Vienna. Jin, thank you for joining us.
Thank you, Joe. Thank you very much.